because,
This meeting is
and I'll
being
explain
recorded.
what that is in a sec. Just let me go back to the screen share. Yeah, sorry, a few people have asked if we can do a recording of this, and the answer to that is yes. So there will be a recording available for data protection purposes, because people might ask questions or might otherwise be identifiable. I'm going to say, if you do want the recording, can you ask me? A few people have asked me already, but if you can, just drop me a very quick email saying, please can I have a copy of the recording. I will be sending a copy of these slides out to everybody who's signed up for today. Right, so let's go. Anyway, so I was explaining that's why we're doing it today, because it's such a common issue. So I thought, seeing as we're just back after Christmas, probably would justify just a quick lunchtime overview of the subject of notice, and also to explore what sits behind the reasons for notice in these cases, just to give us all a broader understanding. That's just a slide with my contact details, website, Twitter, email address, details of the LinkedIn group that I run, which is the Housing Conditions Practitioners Group. So as I say, probably the issue that gets raised most often in these cases, if there's a denial of liability, somewhere in there, there will be a denial of notice in relation to all or some of the items of disrepair. And notice is the trigger for breach, certainly for breach of duty, because as we know, and as many of us take for granted now, what is the starting point for breach of duty is notice of disrepair, then failure to do that work within a reasonable time. I think as we look at that, I think the issues are a bit more subtle than that, and hopefully we can get a slightly different insight as we look at these today. But also it impacts on liability and quantum, because the time scale for assessing damages can also be triggered by the issue of notice. Okay, so there's what we normally do with these cases, and this is what underpins the vast majority of the work that is done on behalf of tenants. I can just say that most of my work, virtually all of the work that I do, reviewing and working with firms in these cases, is from the tenant's perspective. I think there may be one or two here today who look at this from a landlord's perspective, and that's fine. But my approach from this is entirely from the point of view of the tenant. Okay, so there's how we normally approach these cases, and still do, rightly so in most cases, that the landlord has no liability unless and until they know about the defect and have failed to carry out the repairs within a reasonable time. But one thing I just want to do, just to start, and maybe spend the first sort of 10 minutes or so, is this, that the requirement for notice in these cases is an exception. And I'll explain what I mean by that. Firstly, if you look at Section 11 and Section 9A of the Landlord and Tenant Act, as we know, Section 11 is the primary duty to keep and repair the structure and exterior, etc. Section 9A is the relatively new provisions in relation to fitness for human habitation. There's no mention in either of those sections about notice. They are both silent on notice. What that means is they don't create a statutory duty to do the relevant repairs. For example, and I've done lots of health and safety at work cases in my working life. In some cases for health and safety at work, there's a statutory obligation. And so, for example, if under the Factories Act, there's a duty on an employer to keep a passageway in work free from trips and slips, that's a statutory duty. And if somebody trips or slips, there's liability. There's no question of anybody ever having to have complained about it. It might be evidentially important, but it's not at the heart of the case. What Section 11 and Section 9A do is incorporate a contractual obligation on landlords to either do structural repairs or ensure that the property is fit for human habitation. It's breach of contract, and the issue that we're concerned with is, when does that breach of contract occur? And there's a very interesting Supreme Court case from 2016 called Edwards and Kurumasami, which some of you might be familiar with, in which Lord Neuberger gave the lead judgment. And paragraph 29 of that judgment, he spells out what is the general principle in terms of contractual duties to do repairs. Where a landlord or tenant or anyone else covenants to keep premises in repair, the general principle is that the covenant effectively operates as a warranty that the premises will be in repair. That principle has been laid down in a number of cases which were discussed and applied by the Court of Appeal in British Telecom v Sun Life. Accordingly, as soon as any premises subject to such a covenant are out of repair, the covenanter is in breach, irrespective of whether he has had notice of the disrepair and whether he has had time to remedy the disrepair. So there's Lord Neuberger, as recently as 2016, explaining that the general principle in law is that it's a warranty that the landlord will ensure that the property is in repair, and as soon as they fall out of disrepair, there's a breach, irrespective of whether he had notice. Now, before we all start making copious notes for responses, he then goes on to explain that that's the general rule and there's an exception. And he says this: however, this general principle is subject to exceptions, which are based on the normal principles applicable to the interpretation of contracts. The importance of that is the requirement for notice under Section 11 or Section 9A is an exception to that general rule. If the exceptions don't apply, then the general principle the general principle in paragraph 29 of Neuberger judgment applies. So if it comes within the exception, which we'll look at in a second, most of us know what that exception is going to be, then there's a requirement for notice and a reasonable time. If it doesn't come within that exception, then the breach is immediate, not a question of knowledge. It's immediately a breach because of that issue of the warranty. So let's look at that in detail with some cases, and some of you may be familiar with these. And the classic case on these is O'Brien and another v. Robinson from 1973. Just to remind us of the facts, in O'Brien and Robinson, a claimant's husband and wife were in bed and the ceiling collapsed on them, and they both suffered significant injuries. They bring a claim against the landlord, and that claim fails. Why does the action fail? It fails because neither the tenant nor the landlord were aware or could be aware of the developing problem that resulted in the ceiling collapsing. So it was a question of knowledge. Now, just unpacking that a bit, Lord Reid said in O'Brien and Robertson, the landlord's obligation lies in the field of contract, not of tort. And that's the point I was making. It's not a statutory imposed duty. The idea is to fulfill his contract. His duty is not one of reasonable care to avoid injury to the tenant. It's a duty to perform his contract. That thinking was based on the tenant's right of exclusive occupation. You'll notice a typo there, but it's occultation, which is rather appropriate. That's occupation, and I'll correct that before the slides get sent out. So in other words, the nature of the relationship is what precludes the landlord from knowing of the defect O'Brien and Robertson again, if the landlord gives exclusive occupation to the tenant, the landlord does not in fact know, and in this case could not know, of the defect. So the exception to Lord Neuberger's general principle of immediate liability is that because of the tenant's right of exclusive occupation, the landlord doesn't know and cannot know about the disrepair. So that is the exception to the general rule. And I should say from the cases, it's irrelevant that the landlord has a very limited right of entry to inspect. That's not sufficient to say that the landlord would have knowledge. The reality is, because the tenant has exclusive occupation, then insofar as we're looking at items of disrepair that come within that right of occupation, then there's no liability unless there's knowledge. But there's a flip side to that coin, which is if the tenant does not have exclusive occupation, then we go back to Lord Neuberger's general rule. So, for example, back to Edwards and Kurumasami again. Again, if you're not familiar with this case, just a brief reminder of the facts. This was a case where Mr. Kurumasami was Edwards' landlord. Mr. Edwards, I think, was taking rubbish out, and there was a pathway at the rear of the property that was in a state of disrepair, and Mr. Edwards fell and suffered an injury. And a number of issues arose in the Edwards and Kurumasami case, one of which was today's topic of notice. Now, in Edwards and Kurumasami, Lord Neuberger, and just so we understand the terminology, because it comes up in a couple of his quotes, refers to notice, the need for notice, as the rule. So he's explained to us the general principle, contractual liability, as soon as there's a repair, landlord's liable. But there's an exception to that, which Neuberger calls the rule, which is what we've just said, is that if it's the type of repair which the landlord cannot know about because of the tenant's right of exclusive occupation, he calls that the rule. And then what he says about it is this: if a part of the structure included in the tenant's letting is out of repair, then the tenant is in possession of that part of the structure and the landlord is not. Accordingly, the rule would apply to the landlord's obligation to repair that part of the structure. In other words, the rule being that must have notice and there must be a reasonable period of time. But he then goes on to say, however, if that part of the structure is excluded from the demise, it would not be in the possession of the tenant. Indeed, it would presumably be in possession of the landlord, and so the rule would not apply. Now, that seems obvious, but it can have significant implications. So what we're saying here is that if the part of the structure included is out of repair and it's within that area over which the tenant has exclusive occupation, then because of this exception, there's no liability unless the landlord has notice and has failed to do work within a reasonable time. But as I say, the other side of that coin is if it's excluded from the demise, then it's not in possession of the tenant. The rule in Neuberger's, what he calls the general principle, would apply, and there's immediate liability on the landlord. Okay, so in Edwards, as I say, the tenant had been injured when he fell on the defective pathway. As it is, for all this talk about when liability arises and knowledge, in actual fact, the Supreme Court found that the pathway was not part of the structure and exterior. And just as a little aside, and out of interest, what the court found was that the actual sort of immediate entrance area to the property was part of the structure and exterior. The pathway that led to the exit from the property wasn't, but found also that notice was not necessary or would not have been necessary, because the landlord retained an interest in the pathway. And interesting, just while we're on Edwards and Kurumasami, Mr. Kurumasami himself was a leaseholder, so he had his landlord, so there was a head landlord, and then Mr. Kurumasami had a lease, and Edwards was a sub-lessee. As far as the pathway goes, what Kurumasami had was an easement, a right of way, a right to use the pathway, which he then included in his letting to the tenant. So his legal interest in the building was a legal right of way. I just mentioned that as an aside. So it's where the landlord retains an interest in part of the property, therefore in which the tenant does not have exclusive occupation, then that comes within the general principle of immediate liability as opposed to the exception of notice and a reasonable time. If the tenant is not in possession of part of the structure which is out of repair, there is no reason for excluding the general principle set out in paragraph 29 above. And I'm not going to skip all the way back now, but just to remind you again, Lord Newburgh said in paragraph 29, the general principle is as soon as the property is out of disrepair, the landlord is in breach of the warranty that the property will remain in disrepair, and uses that word irrespective of notice. So the tenant not in possession, that is the principle. Summary for this particular bit, but I just really wanted to make quite a big deal of this because I think it does impact on lots of cases. Notice is required in the situation where the landlord cannot be required to perform an obligation of which they are unaware because of the tenant's right of exclusive occupation. Where the relevant defect is outside the demise, then the obligation arises immediately, as does the breach. And that impacts on both liability and quantum. So just to stop and reflect on that for a sec, if the disrepair is outside of the area over which the tenant has exclusive occupation, it's not a question of constructive knowledge. It's not a question of saying the landlord should have known about that repair and done something within a reasonable time. Neither is it a situation a bit like a local authority with a tripping claim, where the landlord could defend the claim by saying, I have a reasonable system for inspecting my properties. Knowledge doesn't come into it. If it's not within the exception, i.e. within the area of which the tenant has exclusive occupation, then there's immediate liability. There are people who've said that that's a bit unfair and possibly they might need to be reviewed at some point. But that is where we are at in terms of disrepair, which is outside the area over which the tenant has occupation. And let's just look at a couple of cases which illustrate this. And this first case is Passley versus Wandsworth, which is in the Housing Law Report. I've not been able to find a reference to it anywhere else, although it is referred to in the Edwards and Kurumasami case. What happened here was that the claimant, Passley, lived in a tower block. Pipes on the roof had fractured due to a freeze. Claimant, Mr. Passley's flat, was flooded. Finding was the council were liable irrespective of notice. Mr. Passley lost property. He was fully compensated because the roof was not part of the demise. Now that raises quite an important point of principle, because he was entitled to damages from the minute the flood happened, because it was outside the part of the area which was demised to him. Therefore, there was immediate liability. The roof wasn't part of the demise. As soon as there was a flood, he was entitled to full compensation. That impacts not only on special damages, but on the period of time over which damages can be claimed. As you know, and anyone who's done my training on this will be familiar with this, we calculate damages for inconvenience normally by way of a percentage reduction in the rent, and then for a period of time from the breach to the point work is done or the conclusion of the case. And so that's how we approach these cases. But in a case such as Passley and Wandsworth, damages are assessed immediately that the incident occurs because of these issues that we're looking at this morning. Another case is Gabriel versus Investing Limited. And again, I've got no report for this case, but it is referred to by Giles Peaker in his Nearly Legal blog, and I've included the link there on the slides. What happened in that case was there was water penetration via the roof. So the district judge found in that case that the roof was not part of the demise and therefore remained in the control of the landlord. So the landlord was immediately liable. And I've also included a reference there to BT versus Sun Life Assurance with the reference there. We're not going to explore that case in detail because really, as I say, I like to keep the webinar short and sweet. But again, that's another case which reaffirms this principle that primary liability under the contract is on the landlord to do repairs, and that liability arises immediately disrepair occurs, subject to the important exception that there can be no liability unless there's notice and then failure to do in a reasonable time. In that situation where the item of disrepair is within the demise, in other words, within the area over which the tenant has exclusive occupation. So what that means in practice is notice will always be required where defects are within the area let to the tenant and over which they have exclusive occupation. So for all that I've just said, that is still going to be most cases. So in most cases that we see where there's disrepair within the demised property, then you're going to have to prove notice, and everything that we're all familiar with and we will look at in a bit more detail shortly applies. It effectively is all cases where the defect arises within, but notice is not otherwise required. And the general rule set out in paragraph 29 of Edwards versus Kurumasami applies. As I say, that impacts on breach and quantum from the moment the defect occurs. Immediate liability and knowledge is not essential. So what sort of situations might we be looking at where that would be relevant to our cases? Well, obviously common parts, by their nature, common parts of the building under Section 11 large A of the Landlord and Tenant Act, and also in Section 9A as well. Common parts, by definition, are not part of the dwelling house which are let to the tenant. And so by definition, there's no question of notice there because that's not something over which the tenant has exclusive occupation. External defects is not part of the demise. So roof, gutters, and windows. The exterior of a block of flats is not normally a part of the letting. Can I just correct a typo there? Sorry, you always do these and then you notice a typo. Let me go back. That should be the exterior of a block of flats is not normally part of the demise. I'm going to make a note to correct that before I send the slide there. Different if it's a house, because if the tenancy is of an entire house, then normally that's what's let to the tenant. Normally the entirety of the house is within the tenant's right of occupation. But any other property involving multiple occupation, the likelihood is that those common areas plus the external areas of the property will be excluded from the demise, and therefore as soon as there's a problem, there's liability, such as the pipes in Passley and the roof in the Gabriel case. So what about cases where the defect arises in another tenant's flat. Before I do that, I'll just deal with a question that someone's posted, because it's particularly relevant to what we've just been talking about. And it says, what about where the problem is in the loft? Well, exactly the same principles apply. If what has led to the tenant is an entire house, as I say, my view of that is, and it depends on the tenancy agreement, excuse me, but in most cases, if the entire property is let, then that would include the external, the internal, and would certainly include the loft, because the landlord in that case would not have the right to enter the property to identify difficulties with the loft. Whereas if there's a loft area on, say, a block of flats, or a block of base nets or whatever, then that is almost certainly excluded from the demise, and the principles that I'm talking about today will apply. At the end of the day, it depends on what's in the tenancy agreement, because that will define what's actually let to the tenant. But in most cases, if it's a house, it's the whole lot. If it's within a block, then it's likely that it's just simply the interior which is let to the tenant, and in respect of the rest of it, the tenant doesn't have a right of exclusive occupation. Just mention another issue which can arise in this, which I've certainly seen, I'm sure many of us have seen over the years, is what about the position where the defect arises in another tenant's flat? So you're in the 3rd floor flat and there's a problem upstairs. Just bear with us 1 second, I'm just checking with these. Right, I'll come back to that in a minute. That's about loft insulation. So I didn't read the full question before. I'll come back to that in a sec. But what about cases where the defect arises in another tenant's flat? Because that tenant has got exclusive occupation. So I'm on the 3rd floor of a tower block. There's leakage coming through into my flat, but the problem that requires attention is in the flat upstairs. Now, that tenant also has a right of exclusive occupation, so the landlord won't necessarily know that there's a problem. So what happens there? Can the landlord defend that case by saying, the occupant upstairs hasn't told me that there's a problem, therefore it comes within the exception, and therefore there's no obligation? All I can say is that there's no easy answer to that question, and I've got Lord Newberger's support on that on that response, that there's no real answer. So it's good enough for him, it's good enough for me, I suppose. But what he does say is this in Edwards and Kurumasami, that in that situation where the problem arises in another tenant's flat, neither the tenant nor the landlord are in possession. The tenant, because he's not the tenant of that property, and the landlord's not in possession because the other tenant has got the right of occupation. And what Lord Newberger said in Edwards and Kurumasami was, the dicta in the cases do not speak with one voice on this question. So there we are. That's, you know, a clear acknowledgement that there's no easy answer to that question. But where so in that case, the pendulum has got to swing one way or the other in that situation. And what Newberger says is this: however, I have concluded that the rule does not normally apply to premises which are not in the possession of the tenant. Most of the dicta describing the reason for the rule rely not only on the landlord's lack of ability to know, but also on the tenant's advantageous position. So what he's saying there is the rule, and remember his rule is, when he talks about the rule, he's talking about the requirement for notice and a reasonable time to pass. And he says that won't normally apply to premises which are not in possession of the tenant. And so in that situation, it's not in possession of the tenant if the defect is affecting somebody else's flat. And so the argument goes, therefore, there's an immediate liability on the landlord because our tenant, our client, is not in the advantageous position. What the cases say is, who's going to know about the repair within the flat? With the tenant, he's the one who knows if there's a leak. He's the one who knows if there's dampness. He's the one who knows if there's a problem with the door internally. And so the tenant has an advantage over the landlord because the landlord can't possibly know those. No such advantage will apply if it's in somebody else's flat. And therefore, Newberger says the presumption is therefore that the requirement for notice won't apply if the problem is emanating from somebody else's. I think that's the answer. It's not particularly clear cut, but we do have that statement from the Supreme Court, which does seem to support that, principle. Just before we move on, just a brief mention, excuse me, about fitness for human habitation, because there is a subtle difference, certainly in relation to one of the requirements of Section 9A. Don't forget, the implied covenant under Section 11 is to keep in repair. And as we know, if it's a case which comes within the exception, the landlord's duty arises when they have notice of the need for the repair and fails to do that repair within a reasonable time. Covenant under Section 9A, 1A is slightly different, isn't it? That's an obligation to ensure that the dwelling is fit for human habitation at the time the lease is granted or otherwise created. So there's a primary obligation to ensure that the property is fit for human habitation from day one. So the landlord can be in breach of that covenant the day the tenant moves in. There obviously can't be any question of notice or knowledge. It's a contractual obligation on the landlord to ensure that the property is fit from day one. So after the tenancy is commenced, the duty then, as we know from subsection B, is the property will remain fit for human habitation during the term of the lease. So I think there's scope there for a distinction. So if the obligation is that the property was not fit in breach of subparagraph A, i.e. was not fit at the time the lease was granted, well, by definition, there can't be any requirement for notice because the tenant, our tenant, isn't even in occupation at that stage. Whereas thereafter, and once the tenant is in possession, is in possession, then I suspect that we move into exactly the same principles that we're talking about today. So from all the authorities, the onus is on the tenant to establish notice. We're coming on now, sorry, we're moving on now to how do we deal with the issue of notice in practice. Can I just say one thing, and I just use this as an example, just on this issue of fitness for human habitation. One interesting context for this, and which does come up in practice, is infestation cases, and we're all seeing more and more infestation cases now. A rat infestation almost certainly will render the property unfit for human habitation, and so if when the tenant moves in, there are rats, then you've got an immediate breach of Section 9A. The property is not fit for human habitation at the start. And there's no question then of whether there's been any complaint, nor is there any question as to what the cause of the infestation is, because you've got an immediate breach of the duty from the start of the tenancy. If the infestation starts on a later date, at some later time, then, as I say, I think there would then be a duty in relation to notice and a secondary argument in terms of what the cause of the infestation is. So I just use that as an example as to how the two different principles can apply. So I did want to deal with that. I think that's was at the heart. That's what I've been sort of working on for the last couple of months, doing research on these, and that is I think the general principle in relation to notice. Just moving on now to practicalities, from the authorities, the onus is on the tenant to prove notice. Don't forget, it's not a test of perfection. It's what is more likely than not. But equally, it can't simply be inferred, but it's not absolute certainty. In other words, the tenant can never say the landlord must have known. If it's a case where notice is required, the onus is on the tenant to establish notice. But don't forget, it doesn't have to be a direct report or complaint to the landlord or their agent, although that's best. Obviously, your strongest case is where you do have evidence of complaints. But it doesn't have to be, and there may be cases where alternative routes to knowledge can be used. It's the knowledge of the landlord that's important, not how the landlord gets it. Remember, the reason why there's an exception to the general rule is that the landlord can't know about the problem unless it's brought to their attention. But the other side of that coin is how that once the landlord has that knowledge, then the duty is triggered. So there can be constructive or imputed knowledge, for example, via workmen or any other person who may be considered to be a reasonable source. One example of this is the fairly well-known case of Denifa v. Jones, which I certainly do refer to when I'm doing my general training in these cases. This is where this was a case where a representative from the council's environmental health department attended the property. It wasn't somebody from the housing department, neither was it in relation to a disrepair issue. It was a public health issue relating to cleanliness. Now, during the course of that attendance, the EHO became aware of issues which came within the council's duty to disrepair. That counted as knowledge, even though he wasn't from the housing department, even though he wasn't there to deal with disrepair, but that was still deemed to be knowledge on the part of the council. Obviously, it was only knowledge that he could see without a formal inspection. There was no duty on the EHO to go and carry out a detailed report and inspection of the property, but there was deemed to be knowledge insofar as it came within what he could see on his attendance. And again, this is another case that some of you might be familiar with, this case of Hall and Howard. In this case, the tenant was planning on buying the property from the landlord to buy the freehold. During the course of that transaction, there was a valuation report was obtained. That valuation report identified items of disrepair which came within the landlord's duties. That was deemed to be knowledge on the part of the landlord. So the tenant is required to show that the landlord or his agent knew or ought to have known about the problem. And I'm just going to take us back to the famous O'Brien and Robinson and Lord Diplock's famous statement. Don't forget, if it's the latter, which is all about timing of disrepair, in other words, a case where notice is required, there is a subsidiary question as to the time at which the landlord's obligation to do the necessary work of repair first arises. Until that time arrives, there can be no breach of the obligation, nor can there be any breach thereafter if the landlord then carries out the work of repair with reasonable expedition. So that is what I use as the classic definition of what is required in those cases where notice is needed. In other words, has the landlord knowledge, and has he failed to carry out the work with reasonable expedition? And I'm just going to mention briefly these two slides, which are sort of side issues, but they are helpful. What's reasonable expedition? whenever I do my training on breach of duty, the next question, after we look at Diploc's statement, failure to do the work with reasonable expedition, is always what's reasonable expedition? And the simple answer to that is there's no answer. For obvious reasons, there's some items of disrepair are very, very straightforward. You know, a window catch might need replacing. That would take a day. In other cases, there might need to be renewal of a number of windows in the property, which would be a longer job and a more realistic timescale. So there's a broad range of what can be reasonable. There is a not particularly helpful guidance in this rather obscure document, the Secure Tenants of Local Housing Authorities Right to Repair Regulations 1994. Just so you know, I've not spent hours and hours researching this. That is referred to in the Legal Action Group publication, the tenant rights. But this gives us some guidance in terms of what's a reasonable time. And there you see it's total loss of electricity a day, partial loss of electricity 3 days, total loss of water a day, etc., etc., etc. It's limited to very straightforward items of disrepair, but is helpful guidance as to what might be or might not be reasonable. Just while we're on that one, the other potential source of information for what's reasonable, and this isn't relevant in every case, but you do come across cases, particularly with local authority and larger housing association tenants, is they have a tenant's handbook, and that tenant's handbook will often include references to repairs with a similar sort of list to what we've got here on this slide. And so this is the timescale within which we will aim to do repairs. If that's within the council's own document, then that can be relied on, certainly as guidance as to what is and isn't reasonable. Subject to that, it's rarely going to be a question of expert evidence. And I've had an interesting discussion today. And one way of approaching this may be to have a range and say, 14 days at one end and say 56 days at the other end, and find somewhere on that line influenced by the seriousness of the disrepair. And that might be a useful way of looking at it, unless, of course, it's an urgent case, which we'll look at shortly, where the timescale can be extremely abridged. So, how else do we prove notice? Well, of course, the classic, we're not going to have time today to go through this in massive detail, but the classic source of evidence on notice is disclosure. Why? Because that is the landlord's own records and is far and away the most helpful source of evidence. You will, and if you do a template, a letter of claim under the pre-action protocol for housing conditions cases, or if you adapt it in some way, on day one, when you send your letter of claim under paragraph 5 of the protocol, you're seeking disclosure, and that disclosure will include the tenancy file and the repair records, and that will therefore include records of complaints, reports, and action taken, and it usually involves a laborious trawl. And just to put things in context, I did spend an hour or so before we kicked off today doing exactly that on a case that I'm helping a firm with. And anyone who's done these cases will know that it's a fairly tedious exercise, normally looking at spreadsheets or other printouts, but it's familiar to most people who do this. It's laborious, but it can produce extremely important evidence. I say it should be done, or certainly supervised, by an experienced practitioner who knows what they're looking for. There's a temptation with these sort of tedious, repetitive jobs just to pass that down to somebody, which is fine, But if it's properly supervised, it does need to be considered by somebody who knows what they're looking at, because there can be subtle issues that are raised on disclosure. For example, there might be different timescales for different defects. You might have a report of a defective window frame in 2017, but then as you trawl through the disclosure, you might find there's no mention of a whole load of other stuff that your client has complained about until early or mid 2021. And so you can have different timescales for different defects. And there is a bit of a tendency sometimes, and we've all done it, when you're going through your disclosure, to say, there's one, there's a complaint about a defective window frame 2017. Therefore, we'll date everything from then. But there may, of course, be different reports and different entries in relation to different items of repair. You can't just look at the earliest, and there won't always be a single timeline. I'm just going to stop there a sec just to see the, that's fine, I'll come to that in a sec. Okay, I just to stop there and raise two issues. One, it says, counsel don't often like to do a case on a CFA relating to constructive knowledge. Well, I'm sorry, that's counsel's problem. I do know barristers that will do these cases on CFA, and those who are familiar with these issues certainly will. The other thing is, of course, is that we're all lawyers. We're all experienced in these cases, or developing and acquiring experience in these cases. You may decide to do your own pleadings, and I know firms, and I work with firms who routinely are now drafting their own pleadings in these cases. And I'm afraid I'm certainly unaware that there's a universal practice with barristers not running these cases on a CFE basis. And the other issue, of course, is if you're instructing counsel effectively and including in your instructions the reasons why it's constructive knowledge, then counsel should be aware of that and respond to it. And of course, the other side, the third side, if we keep flipping the coins over, is from what we talked about today, maybe in cases such as common parts or areas outside of the demise where notice, constructive or otherwise, is not relevant. Okay. Sorry, just going back to the this point about the time scale, make sure you've got your time scales right, because you can sometimes overvalue or in some cases undervalue a damages claim by overlooking that there may be different timescales in relation to different periods of notice and a reasonable response. And I've just used this KS v Southwark just as a very simple example that you can have varying percentage reductions when you're assessing your damages in these cases. And in the Southwark case, there were different periods of time, as you'll see, during which there were different issues on which the position was worse. And so between 09 and 12, there was 35% reduction, 12 to 15 when it was rarely bad, so 50%. And in 2016, when it wasn't quite as bad, 20%. I'm just using that as an example that we don't need to be blinkered when we're looking at disclosure and notice. We should be able to identify in relation to each item of disrepair when the breach occurred and when a reasonable time went without work being done. Okay. Just want to mention something here, and it's something which actually I noticed on a case before Christmas, or last year, which can be really useful. And proper disclosure, proper review of disclosure can actually unearth a case which might not previously have been mentioned. And I use an example. So you're trawling through the tenancy file and you're bored to death and you're having a coffee, and then you come across and let's say your case is all about drafts from windows in the bedrooms, and it looks like a good case, and that's what you're looking for on your disclosure. But then when you're trawling through it, you see an entry from 2017 where a clear complaint was made about a defective boiler with no heating. And that is mentioned a few times again, and then is repaired in, say, 2019. So before you've ever met the client, that particular job has been done, but there's a perfectly good damages claim for that period of time where there's clearly been a breach, where there's notice, the work isn't done, and then a period of time has gone by. And so long as that's within the last 6 years, which is the limitation period, there's a potential claim then. If that's come to your attention, then obviously you will then discuss that with your client and say, do you remember this? And that can add significantly to a damages claim. And the tenant might never have mentioned it because by the time they've instructed you, that's long been done. But as long as it's within the limitation period, there can be a historic damages claim. And I just mentioned that only because it did actually raise itself as an issue on a case that I was reviewing. And if you do unearth a historic damages claim, there's nothing to stop you sending an updated letter of claim if you already sent one, referring to that. And there's nothing wrong with that. Just as a reminder, paragraph 6.5 of the Housing Conditions Protocol does say the letter of claim and the landlord response are not intended to have the same status as a statement of case in court proceedings. Matters may come to light subsequently, which mean that the case of one or other, of both parties may be presented differently in court proceedings. Parties should not seek to take advantage of such discrepancies, provided there was no intention to mislead. So there we go. Matters may come to light subsequently. There's flexibility within this protocol. And if you do become aware of a cause of action that's not previously been mentioned, then you're quite entitled to include that within the case at that stage. So that's disclosure. How else do we prove notice? And it sounds obvious, but it's often overlooked. If the client's own evidence counts, you can have a witness statement with a statement of truth, which is the client's evidence, which is the tenant's evidence of complaints that they've made. A witness statement is central to most other areas of litigation. So if you've got a motor accident, the statement is the statement of how the accident occurred. If you've got a clinical negligence case, the statement may be a long history, including what was discussed and what was not discussed before surgery, for example. So in other areas of litigation, the witness statement is central. For some reason, it's not always treated as central in housing conditions cases, but it's just as good evidence as anything else if it's backed by a statement of truth, as complies with CPR 32. And there was, excuse me, there we see a written statement signed by a person which contains the evidence that that person would be allowed to give orally. So long as it's a statement of truth, that is evidence. And you can't say just because there's no mention in disclosure, therefore the client's statement can't be relied upon. That is clear evidence. And anyone who's ever done these cases, and I'm just responding to a comment that's just come up on the chat, disclosure isn't always perfect. Disclosure does, the landlord's documents are not always perfect. They don't always mention everything. And so there may be gaps in the disclosure, and the witness statement is admissible evidence under CPR 32. So don't overlook the importance of the statement. I did come across one firm I was chatting to in the summer who said there was a local authority in London who were not able to give any disclosure at all because their systems had been hacked. Well, in that case, there's no disclosure anyway, and the client's statement of evidence in those situations is absolutely critical. It might actually be the only factual evidence that there is. This is my approach to statements. Not everybody follows this, and maybe I'm just old school, but this is my approach to witness statements. Should be taken as early as possible. I would always recommend having a statement of evidence with a statement of truth as early as possible, and then built as the case proceeds, not as an afterthought, and certainly not purely in response to a direction to serve by a particular day, which is something we've all done. But my preferred approach is build up a statement in these cases where the history of what has happened can be so time critical. Not limited to complaints, but obviously that's going to be the heart of the statement. Needs to be carefully drafted in the client's own words. And I'll come to it in a sec. In part of my training, I actually recommend use of possibly a template, all full of gaps, but just as a guide through the relevant issues, just to make sure that the statement of evidence is dealing with the issues of evidence. So here's an example. This is from my I do a long template statement as part of the training, but just in this context. So I've complained to my landlord on many occasions, and in particular, provide as much detail as possible. Avoid overgeneralizing and standard phrasing. For example, don't put in a witness statement on more occasions than I can remember, because that's not really telling us anything. Now, it may well be that's absolutely right, that there are more occasions than can be remembered. But I would say that's probably evidentially problematic if that's the only information the tenant can give. And normally, if you explore things in more detail, you can draw from the tenants at least some meat on the bones in terms of when complaints have been made. I'm sorry, this is a sort of template. You can then include details of when, where, how, and what you can remember. And I exhibit here to blah, 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 copies of letters, etc. So that's just a sort of snapshot of the template statement. In response to my complaints, the landlord there's that. My solicitors wrote to the landlord on my behalf. Don't forget your letter of claim under the protocol constitutes notice. And there may be cases where that's very, very relevant, especially when there were long delays during lockdown. You might have sent a letter of claim in January, and for various reasons, it might be September before there's a paragraph 6.3 response. Well, there's 9 months gone by there, and that can be extremely relevant to the issue both of breach and in relation to quantum. How else might we prove notice? Well, again, the obvious things, the client themselves might have documents. Not all tenants are particularly efficient at retaining documents. It can be a bit hit and miss, but it can be extremely useful. Some tenants do, especially these days when everybody has a phone. There may be phone records, emails, letters, and there may also be letters received from the landlord about attendances or in relation to works. So again, there's no shortcut to saying to the client, just give us everything that you can find that might deal with this in order to help us build that case on notice. I'm just going to just sort of wind up with just a few comments, which I've called alternative case strategy, which is really approaching some cases a little bit differently. In other words, acknowledging that the evidence that you've got on notice is not the best, but in all other respects, it looks like a good case. So you might have actionable disrepair. Client might be saying to you, look, I've complained about this, but it's just not giving you an awful lot of helpful evidence to the point where you might think, is this case really one to pursue? And again, going back to counsel, and apologies, well, I know there are counsel here, but if counsel says, no, I'm not running this case because there's inadequate evidence on notice, that's a perfectly valid point. But do we just abandon the case, or do we reconsider our strategy on the case? What do I mean by that? Well, I mean, consider assisting in appropriate cases with notice itself as the starting point. Most of us go straight to paragraph 5 in the protocol and do a letter of claim. But what if you're not satisfied, or you're not that enthusiastic about your evidence on notice? How about building the case from there? It might add weeks or months to the case, but it can also shore up a case on the issue of notice, albeit that the case itself will adopt, or will be subject to a different timescale. So in other words, what I'm saying is, in those cases where you're not otherwise that confident on notice, why not consider assisting the client with drafting a letter to the landlord? Not a protocol letter, not even a letter from you, but a letter from the tenant to the landlord saying, I'm your tenant, you're under duty to do these repairs, here's the repairs. I would like these done within the next 28 days, please, which I think is a reasonable time to do the work. You can advise the client to follow that up if they want to with phone calls and emails. Why is that potentially helpful? Well, for a couple of reasons. Firstly, chances are the work won't be done in that timescale. Local authorities, just with demands and staffing and overall efficiency, probably won't do the work within that timescale. But you've established a trail, a timeline of notice that can be really helpful going forwards. As I say, it might add time to the case, and we all want to get on with our cases, but that can, as part of building the case, can be assisting the client with establishing the evidence of notice. Or even, and the reason why I say or even, anyone who's ever done any of my training courses or ever talked to me about a case will know that the big topic that I rant about more than any other is where local authorities refuse to engage under the protocol, saying that we haven't used their internal complaints procedure, and quite rightly so in most cases. But there is another side to that coin. Is it may be that if you're not that enthusiastic about the evidence you've got on notice, maybe advise the client to do it, to do the complaints procedure. It's certainly encouraged by the protocol. Paragraph 4 of the protocol includes, and I know, as you know, I always say this as part of a list, includes for council tenants the council's own complaints and or arbitration procedures. That's not compulsory, but there may be appropriate cases where it's worth doing it in order to build the case on notice, and also to head off other difficulties going forward. That's why it can be a double benefit. It could be evidence of notice, but also head off paragraph 4 of protocol arguments raised by some local authorities that the complaint procedure has not been used. I'm just throwing that in there as something to consider in appropriate cases where your other evidence on notice might not be that good. In other words, to build up the case on notice. Don't use it with the clear evidence from the client, but could also underpin a case where in other respects, the repair is actionable. So you can actually make that part of a different type of case plan in difficult cases. Some areas of work, and I used to do clinical negligence cases in practice with legal aid before 2013. You couldn't get legal aid on some cases unless you could produce evidence of having used the complaints procedure. So that's something which practitioners have got used to in some areas of work, and it just might be worth throwing that into the equation in these cases, if it's one where otherwise there's difficulties on notice and the temptation would otherwise be to abandon the claim. Okay, and as I say, from experience, it's unlikely that work will be done, and so you've still got the case to pursue. And I've just included a reference to a press report there where a local authority was heavily criticised by the Ombudsman for failure to deal with complaints. I think the actual detail was around about 5,000–6,000 complaints had not been appropriately dealt with. So chances are the work won't be done. And I'm aware of a case where, and again, it was a Bristol case, where they failed in their argument that the claimants had not used a complaint procedure because there was no evidence that it would actually have resulted in anything being done. Well, again, that's something to bear in mind, is you might want to use the complaint procedure to build up your case, and it's highly unlikely that's going to result in the work being done. And it's just something to bear in mind and something to think about. Just a brief mention of emergency repairs, active water penetration, sewage backing up, no heating. In fact, cases where you might consider applying for an injunction, they're unlikely to have a long history. There may be a long history if it's part of a longer story, but these sort of cases tend to be immediate. And because of that, certainly the protocol anticipates that you might want to bypass the timescales, particularly into expert evidence. In many cases, there may still be a requirement for notice, but there's nothing to stop you or advising the tenant to give immediate notice and say a reasonable time to do this repair is 24 hours, and then just getting on with it. So always bear in mind that there are emergency cases where most of what we've talked about today is not going to be appropriate or relevant. And that, you'll be pleased to know, 1:10 is that. Let me just stop the screen share. Just got one more question. If the landlord suggests using the complaint procedure and refuse to display disclosure, your advice would be to encourage the client to do so. No, that's not actually what I'm saying. What I'm saying is horses for courses. And so there may be cases where if you're not that confident on the client's own evidence of complaints, that you might want disclosure. I would tend to just get on with it. I'm not saying you should adopt the complaint procedure. I'm saying you should keep it in your back pocket as an option in cases where your evidence on notice is not otherwise that good. In other cases, if you do have it, I would just get on with it. I'm not a big fan of pre-action disclosure proceedings. I just think that gives some landlords a platform to make some of the points they like to make about complaint procedures and whatever. My own preference is just to get on with the case if possible. So what I've said about using the complaint procedure, I'm not saying you should. I'm saying it might be worth, as I say, keeping in your back pocket in cases where your evidence is otherwise not that good. Another question, do you consider extractor fans as Section 11 disrepair? This gets raised all the time on cases, and it really does depend on what the issue is. And that and Section 9A also comes into play here. So the question is, do you consider extractor fans as Section 11 disrepair? If there's no extractor fan at all, it's not Section 11 because there's nothing broken. The classic definition of repair under Section 11 is something has to be in such a state that it requires repair. And if there's never been an extractor fan, then that's an improvement. It's not a repair. If there is an extractor fan and it's not functioning properly, then that is Section 11 because the extractor fan will be part of the structure and exterior of the dwelling house. And if it's in a state of disrepair, then it does come within Section 11. So that's the subtle difference there, where there is one or where there's never been one. The other issue, which is worth thinking about, is Section 9A, because the duty under Section 9A is to ensure the premises are fit for human habitation. If you've got a serious problem of condensation causing mold, which we know is prejudicial to health, even before we had Section 9A, and in fact, prescribed hazards under the Housing Act 2004 are now taken into account under Section 9A. Mould is a hazard, and so there may be an actionable case, even if there's no extractor fan and there's never been one under Section 9A, if the effect of that is to render the property unfit for human habitation. Next question, what are you hearing about cases being rendered small claims where the landlord gets the work done soon after receiving your letter of claim, but deny the claim, happening commonly? Now, we haven't got an awful lot of time today. As I say, we're focusing on notice today. What I can say is, if you look at the case of Birmingham City Council against Lee, which is very important on this point, what happened to Birmingham City Council against Lee was exactly that. Solicitor, and this was back in 2008, solicitors sent a letter of claim. Birmingham City Council did the work right away and said, we're no longer talking to you and you're not getting any cost because all you've got left now is a small claim. That case went to the Court of Appeal. Lord Justice Morgan, I think, gave the lead judgment. And what he said was, if a tenant has got a problem of disrepair, they need help from a lawyer in drafting the appropriate letter under the protocol and should be entitled to their costs of getting that assistance. And in Birmingham City Council and Lee, the costs were split. What happened was the case, I think, was issued in the small claims track, but then there was a claim for costs within the small claims track, and the Court of Appeal made a split costs order and gave the claimant costs on a standard basis up to the point the repairs were done, and thereafter it was within the small claims costs. So that's the position on that. As I said, it's a much more longer, more complicated argument, but don't just throw your hand in on that one. There is certainly a very clear and a firm argument. And again, there's another case involving, I think it's Bristol City Council, where again, that principle, this was in 2021, where that case of Bristol City Council versus Lee was applied. Next question, if the client proceeds to use the complaints procedure and the landlord does repairs within a reasonable time, how will this affect the housing disrepair claim? Okay, well, I think, refer to the previous question, really. Don't forget, I'm not saying that you should use the complaints procedure. I'm just saying you should bear it in mind as a possible way of establishing notice if you don't already have it. And so it's going to be in the exceptional cases. It's not going to be the norm. If that happens, then we're back to the Birmingham City Council versus Lee situation. It's difficult to explain to a client why you're not going to do something which will result in work being done when that's the idea of the exercise. But as far as the tenant is concerned, that's what they want. Now, if you've got adequate evidence of notice and you're happy to get on with it, I would just get on with it. Don't forget, when it says if the client uses the complaint procedure and they do the repairs, one is they're not likely to. And secondly, they're no more likely to than they are after getting a letter of claim under the protocol. The same principle will apply. They could always go out and do the work, which is the thinking behind the Birmingham City Council and Lee decision. Next one, if the client has already engaged the complaint procedure, then a letter of claim is sent out. If the landlord refuses to engage with the letter of claim until the client drops the claim procedure, what would you do in that situation? I'd just get on with the case. Sorry, if they're still in breach of their obligations under Section 11 or Section 9A, then whether they refuse to engage or not is entirely up to them. If you've got a case where you can now establish notice, then I would just get on with it. Right, somebody's just reminded me of the case of loft insulation, which we talked about before. They've laid it, but not properly, and there's a leak in the roof. Is the insulation part of the structure? Yes, it is. If it's within the leak area, I would definitely say it's part of the structure and or exterior of the premises. I would say it's in an area of the building that's not let to the tenant, and so it's not within the right of exclusive occupation. and I would certainly pursue that claim. And the last question I've got for now is a reference to Berry versus Jalili, which I've not referred to today because today is about notice. Berry and Jalili is about quantum. What Berry and Jalili was about was this, that the local authorities' estimate of cost of repairs was significantly less than £1,000, which meant small claim. The claimant's estimate of repairs was about 3,500, which was well within. And the issue was that Berry Council were arguing that it should be assessed on the basis of their in-house maintenance team doing the work, as opposed to external contractors. And in that case, Berry's argument prevailed before a district judge. I should say that it could well be limited to its fact. I've spoken to surveyors since about Jalili who say, no, there are certain standards of repair which are required and will give some indication as to what the appropriate cost is to do those repairs. But it's ultimately, I think, a question of expert evidence. I do encourage surveyors that I work with now to anticipate that that could be an issue. And I should say it is being used more, but not universally. Not all local authorities are using Berry versus Jalili. Effectively, the Berry versus Jalili principle is the cost of repairs is less than we say it is because they can have it done in-house by their team. And that was accepted in the Jalili case. And so we can't say that that's not an issue. In practice, it's not simply a question of the local authority just plucking a figure out of the air that happens to be less than 1,000. They do have to justify it on the evidence. Next one is gas engineer good enough to produce constructive notice? Well, yeah, I would say probably, thanks Julie for that. I think that is, because if the gas engineer has been sent out by the landlord, then instructed privately by the landlord, and during the course of that becomes aware of issues, then I would say that does establish notice. But bearing in mind that the more specialist the discipline of the person who attends, the more limited the scope for arguing notice. So if a gas engineer comes out within the context of his expertise, that might establish constructive notice. But if it's a bit drafty, he's probably not an expert to say that there's a problem with the window frames because it's completely outside of his expertise. Well, that was a really good set of questions there. Thanks, everybody. I learned quite a lot there as well. And we're now at 1:20, so we've almost done it within our time scale. So I hope you found that useful. I am happy to field any questions by email afterwards, which I always try to do. I will send slides out, and as I say, there will be a recording available at the end if anybody finds that useful. So subject to that, I will sign off and hope you all have a good day. Bye all. Good day. Bye all. I'm also stopping the recording.